All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated, veuillez vous asseoir.
Good morning, bonjour. Good morning, everyone. Good morning, Mr. Said. Mr. Court Officer, would you please call the case?
Good morning, Mr. President, Your Honors. This is the second situation in the Central African Republic in the case of the prosecutor versus Mohammed Said Abdelkani, case number ICC 0114-0121. And for the record, we are in open session.
Thank you very much. So now, according to our schedule, it's the time for the legal representative of the victims, for the OPCV, to present her closing statement. You have 30 minutes, but if you need a little bit more, I will allow so, since you have not spoken before, and we want to hear the voice of the victims. Thank you very much.
Merci, Monsieur le Président.
Thank you, Mr. President. I'll try to remain within the 30 minutes that have been granted. Maybe plus 1 or 2 more minutes, but I'll remain within that bracket. Mr. President, Your Honors, I have already recalled the crimes that Mr. Said is suspected of having committed in my opening statement, and I will not repeat that. The same applies to victimization. Those crimes occurred within the framework of the implementation of a common plan whose purpose was to target presumed supporters of Bozizé in Bangui and to commit such crimes charged in the DCC at the OCRB and at SEDAD. This common plan was implemented pursuant to a more global policy of Seleka, which sought to maintain the organization in power. The existence of this policy was confirmed on Wednesday morning by the defense itself when it said, and I quote, "The only element that will somewhat briefly link part of these groups that operated independently from each other was their dissatisfaction with President Bozizé." I'm referring to the French transcript, real time, number 5, page 10, lines 17 to 21. And which was confirmed at pages 17 and 18 when defense simply endorsed a prosecution expert's explanations in the Ngaisona and Yekaton case. The recent jurisprudence of the case has established in this regard, and I cite in English as follows.
A policy may consist of a pre-established design or plan, but it may also crystallize and develop only as actions are undertaken by the perpetrators. À cet égard, vous pourrez
I refer you to the judgment of pre-trial chamber 9, number ICC 020401151762, read of 4 February 2021 at paragraph 2679.
Madame, Messieurs les juges,
Your Honors, in spite of defense's efforts, that is, Mr. Said's defense efforts to persuade you and to persuade us that no common plan existed, the evidence in the case file provided by the prosecutor demonstrates that such a plan was actually designed and implemented, and that Mr. Said played an essential role in that plan as a colonel, high-ranking leader of Seleka and the de facto leader of OCRB as well as Commander of Operations at SEDAD and Supervisor of Staff. Mr. Said knew, he encouraged and supervised the commission of these crimes against the victims. He did not do anything to avoid the commission of such crimes, and he even committed some himself. It is paradoxically behind this screen that the defense seems to hide in order to force the chamber to look away from the suspect and focus its eyes simply on what defense refers to as being the highest responsible officials. Defense will further on go to accuse the prosecutor about its investigations because they simply focus on the activities of Mr. Said and not of other members of Seleka. Reference transcript 04 French real time, page 43 to 45. Yes, the defense has tried to get us to believe that Mr. Said should not be prosecuted by this court and that his superiors should be prosecuted instead. This is absurd, Mr. President, Your Honors. On Tuesday, I explained this. The confirmation of charges hearings is an important step in the reconstruction of the lives of victims who are expecting an outcome on their fate, and they have been waiting for too long. Clearly, victims will be very happy for Seleka suspects of the highest ranks to be prosecuted, but their absence from the dock does not exonerate Mr. Said in any way, contrary to what Mr. Said's defense has attempted to explain. And I refer here to transcript in French, number 4, page 34, 43, and 44. Incidentally, I note that while the defense has failed to demonstrate that Seleka was a disorganized entity, and I will revisit this point, the defense never, however, contested Mr. Said's belonging to that association, nor did it a fortiori challenge his role in that organization, particularly at the OCRB and at SETAD, within the time mentioned in the charges. Maybe Mr. Said was the only member of that organization who was not opportunistic in changing groups depending on the development of events. And I'm referring here to what Madame Naoni said in transcript 5 French, page 5 and 6. Mr. Jacobs tries to get you to believe that it is normal, and I quote, it is normal that Mr. Said was a volunteer taking part in the management and ensuring that staff working at the OCRB were provided with food and the resources to discharge their peacekeeping mission. It is, in fact, even more normal, he said, that the suspect was a volunteer who worked voluntarily in the reception and sorting of persons who were arrested. I'm referring to the French transcript, number 5, from page 44 to 45. Furthermore, even when we look at defense's arguments on the colonial past of the Central African Republic and the ghost state structure, which underpin their argument as corresponding to the contextual history of this case, and reference French transcript 004, real time, page 28 and 29. Even if we were to agree that these arguments correspond, at least in part, to the historical context of the case, such acts cannot justify, let alone annihilate the criminal responsibility of the perpetrators of those crimes, particularly Mr. Said. The defense provides arguments on the meaning of Seleka as being a coalition, but that is not clear. It is semantics that defense is using to try to hide reality. And I refer you to transcript number 4, French, page 29, from line 14. Similarly, they refer to the lack of staff at the OCRD, which is part of defense's argument. Transcript number 4, French, page 31, lines 14 to 18. If we were to set aside poor Albert Camus and all the ills of the world, let me simply recall that Seleka, that group, that organization, which was possibly made up of various subgroups, which doesn't deprive it of being a group in any event, is referred to by itself as Seleka. So this is not a word that comes out of the figment of the office of the prosecutor. Incidentally, while they complain that the highest officials of this very Seleka are not in the dock instead of their client, the defense in so doing contradicts its own theory, whereby there was no theory. So where there's no group, there's no organization, and there's no structure. That having been said, Mr. President, Your Honors, if we were to give any amount of credit to the paradoxal reasoning and unconvincing reasoning of the defense, which argues, and I quote, that the grades used by individuals within Seleka are of no significance and particularly do not reflect the existence of a global or general organization or of a hierarchy. Reference French transcript number 5, pages 33 at line 12 to 14. So if we were to ascribe any value to these arguments, the idea of inculpating the highest officials of the organization which I have just mentioned in relation to Mr. Said should be set aside in limine. On this point, Mr. President, Your Honors, let me strongly state that by so dismissing the entire body of evidence provided by the prosecutor against the suspect and referring to them as slander, as was said by Mr. Jacques Comin when he mentioned that something of it will always remain, all of this is not worthy. I would refer you to French transcript by page 55, lines 1 to 5. The victims, I repeat, were arrested violently and imprisoned, and not simply received in prison cells as defense would have us believe. They were tortured for days, sometimes for weeks, under inhumane conditions, and the chamber is now aware of these things. The victims were not simply sorted out as the defense would have you believe. And all of this was done under the orders by the orders of Mr. Said. And it all happened literally in his office in some instances. The defense has repeated its submissions several times, even before the confirmation of charges hearing. I refer you to document ICC 01 175 Red 2 and document 21164. The defense has failed in this effort, but continues to give a role that is different from that of the confirmation of charges hearing as provided for in the text, or in the text and the legal text of this court, and the jurisprudence flowing therefrom. Mr. President, Your Honors, the confirmation of charges hearing is not a trial, but a preliminary hearing at which the prosecutor presents to the judges the evidence that is sufficient to bring the matter to trial. In Bakbo, document ICC 021101-11325 of 14 December 2012 at paragraph 22, the pre-trial chamber 1 determined that the confirmation of charges hearing has a specific goal and a limited scope, and this was confirmed by subsequent jurisdiction. I quote in English.
One of the purposes of confirmation of charges is to fix and delimit the factual scope of trial. Le paragraphe 27.
That is at paragraph 27. Ultimately, therefore, we must bear in mind that in the matters of administration of justice, it must be strict, and there is a limited scope to evidence as well as to the distinct rules pertaining to the administration of justice. And this was also equally recalled by Trial Chamber 5A in the Ruto case. Reference document ICC 010901111334 of 3 June 2014 at paragraph 14. By the way, in the practical guide for proceedings by chambers, often referenced by the defense during this hearing, the judges recall as follows: in order to avoid prejudice on any issues or ascribe prematurely probative value to any evidence, only material that is before the court during the trial will be taken into account. And in that regard, the chamber will limit its reasoning to what is necessary and sufficient for the purposes of its determination on the charges. And I'm referring to page 18. And once again, the guide provides that the pre-trial chamber must verify that the charges enable the suspect to identify the events in question and the criminal conduct that is alleged, so that the suspect may defend himself thereof. This is at page 13. I'll stop there and point out in this regard that the prosecutor equally insisted on the limited scope of the evidence at this stage of the proceedings in their closing statement yesterday. I'm referring to transcript number 05 in French, real time, page 67, lines 14 to 19. Defense also continually repeated the same arguments throughout the hearing and went on to actually endorse the same method it challenges the prosecution from, namely the presentation of loose arguments that are without legal foundation. In so doing, it fails to discharge its duty of presenting organized and structured observations, and this in spite of their use of a PowerPoint presentation. The defense, in so doing, simply presented its own reading of history without providing any probative arguments that question or challenge the evidence provided by the prosecutor. In that regard, defense referred to the corrective functions and the various proceedings that held before the confirmation of charges hearing pursuant to its right under Rule 1223 of the Rules of Procedure and Evidence. Defense underscored the essential nature of the DDC and of the PCB as a base for their work, and went on to allege that the two documents were not clear and that there was no demonstration of the allegations contained therein established. I'm referring to the French transcript 004, page 37 and 38. In so doing, the defense undertook a comparison exercise, but let me point out that that defense was provided a detailed DCC and a list of evidence as well as a pre-trial brief, and that goes beyond the statutory requirements for the prosecutor. Let me further say that when defense argues that it is difficult to navigate this vast amount of documents, that is a baseless argument. The argument about lack of specificity and ambiguity in the documents and a failure to demonstrate the existence of such arguments, all of these, I believe, are without basis. But, Mr. President, Your Honors, it is neither for you, nor for the prosecutor, nor for the victims to stand in for the defense, which simply pointed at deficiencies in the pointed to alleged deficiencies without substantiating such deficiencies in relation to the consequences of these shortcomings of the prosecutor, these alleged shortcomings on the work of the defense and on the outcome of the confirmation of charges hearing. Finally, it is clear that defense is short of arguments and cannot confirm its assertions, and therefore relies on incomplete quotations that are extracted from a number of texts to substantiate their own arguments, and in so doing might mislead the chamber. An example was pointed out yesterday by the prosecutor relating to the United Nations Commission of Inquiry report, and I refer you to transcript 05 English, pages 81 to 82, and I will quote in English because this part is not complete in the French transcript at page 70. So, let me refer to what Mr. Jacobs said yesterday morning in the opening statement. The counsel did not read out the entire quotation, which is as follows. Detainees were held under inhumane conditions because simply they lived in certain neighborhoods of Bangui and which were known to be the bastions of Bozizo in 2013, because some of them were of a certain ethnic group, Baya or Banda, because some of them were of a certain religious inclination, or because some of them were working in the administration that had been overthrown. And this is the excerpt that was left out. And because the Seleka felt that made of them persons who were Bozize supporters. And this can be found in the French transcript 004 at lines 24, or rather page 24, lines 15 to 21. Mr. President, Your Honors, defense further challenges the legal qualification by the prosecutor under Article 7.1k of the Rome Statute, an article which, according to defense, lends itself to a controversial interpretation, and therefore they argue that the crime should be set aside for lack of precision. Reference T004, page 34 and 39. Defense argues that using this article should only be exceptional, otherwise it will be a catch-all provision. But let us refer to the preparatory work or the travaux préparatoires of the Rome Statute in the International Law Commission Directory of 1996, Volume 2, Part 2, page 53, paragraph 17, where, according to the jurisprudence of this court, which confirms that this is not the case and that it is not catch-all, the various criteria of this category are actually set up and can be applied. The Trial Chamber 9 recently set up some guardrails in relation to this judgment, and I refer you to the ongoing case in its judgment of 4 February 2021, document ICC 02040115-176, read paragraphs 2741, 2753. One of the findings of that chamber is particularly applicable in this case. And I want to quote paragraph 2744 in English rather, and I refer you to the footnote of that relevant citation. That will be footnote number 7205. I quote in English.
International case law suggests that serious beatings, subjection to deplorable condition of detention, and requiring persons to witness the beatings or killings of others can constitute other inhuman acts. En ce qui concerne la spécificité
When it comes to the specificity of these crimes, the Chamber continued as follows at paragraph 2747, and I quote in English.
En anglais, toujours. The Chamber can enter a conviction under Article 7(1)(k) if the perpetrator inflicts great suffering or serious injury to body or to mental or physical health by means of a course of conduct which, despite comprising also acts falling under one or more of the enumerated crimes, is in its entirety not identical, but nonetheless similar in character, in terms of nature and gravity, to those enumerated crimes.
Finally, the Chamber also specified that it is not necessary for the perpetrators to have had to make a valid judgment on the inhumane character of the act, and that it suffices simply to establish that the perpetrator knew that the circumstances would be relevant to that character. And I'm referring here to paragraph 2774 in the Ongwen case. Therefore, the evidence of the prosecutor is sufficient to demonstrate that those crimes existed, both in relation to the inhumane and deplorable conditions in which Mr. Said's victims were held, but also, as suggested by the prosecutor yesterday, in relation to the families of these victims who were abducted and held in secret and who knew nothing about what was happening to their relatives, and who went through hell in addition to the terror that they must have felt through these events. I'm referring to transcript number 4 in French at page 80 and 81. Let me conclude, Mr. President, Your Honors, by saying that the prosecutor has demonstrated that there is sufficient evidence to establish the existence of substantive reasons to believe that Mr. Said committed the crimes charged, and that such crimes meet the probative threshold required under Article 61(5) of the Rome Statute. All of these facts have been demonstrated or established by the prosecutor with sufficient evidence at the level of the confirmation of trial, confirmation of charges trial, to enable the pre-trial chamber to come to a determination. And on these grounds, Mr. Said should be referred to trial. I thank you, Mr. President. Thank you, Your Honors.
Thank you very much, Madam Counsel, for your PCV. Now, this leads us to the final statements for the defense. Madam Counsel, the floor is yours.
Merci, Monsieur le Président.
Thank you, Mr. President.
Monsieur le Président,
Mr. President,
Madame, Monsieur les juges,
Your Honors,
après avoir lu
after having
dans le
read
détail
in
le
detail the DCC, the PCB,
et après avoir écouté
and
attentivement
after
l'accusation,
having listened with keen interest to the
nous posons la question de la
prosecution,
recherche de la
we are putting the question of the ascertainment
réalité
of the truth.
que l'accusation a prétendu
Is
donner
the
à voir à la
reality
Chambre
that the prosecution claimed to have
Ceci a pu se
portrayed
dérouler
before
en
the
RCA
chamber comes
entre
close
mars
to
et
the
décembre
truth
2013.
of what may have really happened in
Et
the
c'est une
car
question
between
fondamentale
March and December
parce que
2013.
la manière
And
dont
this is a
l'accusation a cru
fundamental
comprendre la
question
situation
because
a des
the
conséquences
prosecution's
importantes.
understanding of the
C'est sur la
situation
base de sa
has
compréhension de la situation
important
qu'un mandat
consequences.
d'arrêt a
It
été
is on the
délivré
basis
contre
of his
Mr. Saïd.
comprehension of the situation that
C'est aussi
an
sur la
arrest warrant
perception
was
des
issued
rapports
against
sur le
Mr.
terrain
Said. It is also based on the perception of his
que s'explique le
dynamics
choix de
on the
l'accusation de
ground
faire porter ses efforts
that
contre des membres
explains the
de rang
decision of
subalterne,
the prosecution to channel
ce
its
qu'elle
efforts
perçoit comme
against
faisant partie de
low-ranking
Sénéca,
members of what they
sans pour
perceived
autant
to be
s'intéresser
the
aux
constituent
hauts
parts
responsables du
of
gouvernement
the
en transition du président
Seleka
Danja.
without looking into the highest ranking officials of the transitional government of President
Ou même aux
Jotodia,
personnalités les plus
or
importantes
even
de ce
the
qu'elle décrit
most
comme étant
prominent
la Séléka.
personalities of what they described as being the Seleka.
Ceci explique aussi
This
son
is
choix
what also
clair
explains
traiter les
its
anciens hauts responsables du
unequivocal
gouvernement
decision to treat
et
the
ceux qui en
former
font
high
actuellement
officials of the
avec
transitional
mansuétude.
government and those who are actually part of the current
Jamais
government with
Jusqu'ici, la
leniency.
vision de l'accusation
Never,
n'avait
up
été
to this
discutée en
point,
profondeur.
was the vision of the prosecution examined in depth. The issue was
Jamais
examined
la
in
réalité
general terms.
de ce que
Never
recouvrait Séléka,
was the reality of the
ce que recouvrirait le Séléka,
contents of the Seleka, what the Seleka
la
really
Séléka
covered,
d'un débat
was the subject in adversarial debates.
Jamais
Never
qualification de la
was the
situation en
characterization
RCA
of the
entre mars et
situation
septembre
in the
2013
car between March and September
n'avait été débattue devant les juges de la Cour.
2013 ever debated before the judges of the court.
Jamais
Never
l'existence,
was the
précisément
existence, or more
l'absence
specifically the
d'un conflit
absence
armé pendant
of
la
an
période
armed
de
conflict
mars à
between the
septembre
period
2013
between
n'a fait l'objet
March
d'un
to
débat
September
contradictoire.
2013 was the object of an
Jamais
adversarial
le fonctionnement de la structure
proceeding.
de l'État de
Never
RCA
was the functioning of the
sous le
structure
gouvernement
of the state
président
of the
Jotodia
car
n'a été
under the
discuté.
government of President Jotodia was ever debated.
Jamais
Never
le contexte
was the
de
context
chaos
of
et
chaos and
prévalant à RCA
criminality prevailing
mars
in
et
the car
décembre
between March
2013
and
n'a
December
été analysé.
2013 was ever analyzed.
L'accusation
The
pouvait exposer
prosecution
ses thèses sans
could
crainte
have
de
dealt
injustice.
with all these matters without any fear of
Faute de
contradiction.
débat contradictoire,
In the absence
la
of an
Chambre n'a pas eu
adversarial
l'occasion
debate, the chamber
d'en
did
juger
not
la
have the
pertinence
opportunity
ou bien
to
fondée.
assess the
C'est désormais
relevance
chose
and
faite.
validity of these
Nous
submissions.
avons, lors de cette
The
audience,
deed has now been
discuté
done,
des
and
présupposés
during
de
these
l'accusation.
hearings, we have discussed the
Chacun de ces
assumptions of the prosecution.
Les éléments de
Each
preuve
of
qu'elle a
his
présentés
arguments, the
et les
evidence
conclusions
that they have presented, and the conclusions drawn
Alors, que
therefrom.
vous dit l'accusation?
Now, what does the prosecution tell you?
Elle nous dit que l'examen minutieux de la
They tell
crédibilité
us
des témoins
that
à ce
the
stade de la procédure
methodical examination of the credibility of the witnesses is not necessary. page
Mais
67,
alors,
lines 9 to 13 of the transcripts.
l'audience serait-elle une mascarade de débats contradictoires?
Is the hearing a masquerade of
Il faut bien le constater.
necessary
À l'issue de cet
adversarial
examen
debates?
approfondi, il ne reste rien de sa construction de débat.
The fact must be duly noted at the end of this
Tout l'édifice
in-depth
soigneusement
examination,
construit
nothing
s'effondre.
remains of the prosecutor's initial thesis.
était
The
construit
entire
sur des
edifice,
fausses
which
prémices,
was methodically
des a priori,
constructed, is
sur
now
des
in
amalgames
ruins. Why?
historiques,
Because it was
culturels,
built on sand, on false premises, presumptions,
La
on
démonstration de l'accusation
historic,
repose sur deux
cultural,
points.
and political affirmations. The
part,
demonstration of the
l'affirmation
prosecution
que la
is
Seleka
based on two
existe.
pillars. On the one
Comme un
hand, the
groupe
affirmation that Seleka
structuré,
existed as
capable de
an
répondre à une chaîne de
organized
commande.
and structured group capable of reporting to a chain of command.
D'autre part,
On the other hand,
que le gouvernement de transition
that
d'Aïcha
the
Tchadja
transitional
était en
government of
réalité
President
structure,
Jotodia was in
selon elle,
reality
Seleka,
a structure,
et elle entretient à dessein la confusion
namely
entre ce
the
que serait la
Seleka,
Seleka
and
et ce que serait le
thereby
gouvernement.
they deliberately created confusion between what Seleka
base de
could
ces
have
deux
been and what the government could have been. On the
L'accusation
basis of these two pillars, the prosecution claims,
Premièrement, qu'un conflit armé
first of
non
all,
international
that a non-international armed conflict allegedly raged in the car between March and September 2013, and secondly, that all the state structures, including the OCRB and the SEDAT, were supposedly Seleka bases and therefore instruments of the so-called Seleka policy.
Nous avons examiné cette théorie
We
sous
have
différents angles
examined this theory from various perspectives during the hearing. From our point of view, the theory of the prosecution could not stand scrutiny, and the pillars of their arguments have turned out to be made of sand. We have in fact demonstrated during the hearings how the attempt to engage in the path of least resistance and simplification has serious consequences, and the accusation misinterpreted the events that they are talking about. Let us begin with the foundations of their arguments. First of all, the prosecution ignores the context within which an ephemeral movement made up of civilo-political armed movements came into being, and that has misled them. In the opinion of all the specialists of the CAR, the creation of civilo-political armed groups as from early 2000s was motivated, before everything else, by local economic interests. These were opportunistic groups that were progressively considered by observers as rebellions, and which ended up in 2012 by forming a temporary coalition. What does the prosecutor tell us about these groups? Nothing. Nothing in the DCC, nothing in the PCB, and nothing at all in the courtroom itself. We have heard them talk about the anti-Bozize and the anti-Balaka, both during the presentation of the presentation and in their closing arguments. They gave us long presentations on these armed groups. And yet, we are not dealing here with the Yekatom and Gaisona case, and so why therefore have they not explained to us what Seleka is? Why did the prosecution not even make an attempt to talk about its creation? Why did the prosecution remain tongue-tied when it came to explaining the groups that made up Seleka? Why is it that the prosecution fails to explain its structure, how orders were communicated, how were the alleged chains of command functioning? Why does the prosecutor limit themselves to refer in a perfunctory manner to only a few groups without ever explaining how such groups functioned as a collective? Because by choosing to overlook these elements, the prosecution can circumvent the need to detail the large number of those groups, the internal power struggles, and in so doing, the prosecution spares itself from facing up to the fact that these groups made up a nebulous entity of people unsatisfied with President Bozize. So to skirt around this obstacle, the prosecution presupposes or prefers to assume the existence of the coalition. A simple analysis of the foundation used to demonstrate its thesis by the prosecution exposes its fragility. Seleka was not a hierarchical or organized structure, and it did not have a chain of command, and it was not guided by any given objective. Faced with this unimpeachable acts, the entire edifice crumbles. The alleged or assumed Seleka never existed as an organized or structured group, and so the Seleka could not have been a party to an armed conflict and could not have morphed into a state structure. With regard to the absence of the armed conflicts between March and September 2017, demonstrated by unanimous literature, the reports of specialists are unequivocal, and the settled law is clear. At the very earliest, the armed conflict in the CAR began only as from the month of September 2013. Prior to that date, the CAR experienced unrest and internal tensions reflected in the isolated and sporadic acts of violence. It would seem that the prosecution hopes, within the framework of the case before us, to obtain a result that is different than the result obtained in the Yekatom and Gaisona case. That is not the case here. In the instant case and in the absence of an armed conflict between March and September 2013, there simply was no war crimes that could have been perpetrated during that period. All allegations made by the prosecutor of war crimes collapsed, and consequently, there is no doubt that the charges of war crimes must be dismissed. We would then be left to focus on the allegations related to the commission of crimes against humanity. To that end, it is necessary to look into the transitional government of President Jotodia. It should be noted here that the prosecutors had an incomprehensible attempt to prove the existence of a strategy which apparently was devised by Seleka and implemented by both the Seleka and state structures. The prosecution relies on the premise that Seleka was the state and that as a result, the OCRB and SEDAT were Seleka bases.
L'accusation en veut pour preuve
The evidence for that,
que le
as
décret
put
de
forward
nomination
by the
du président
prosecution,
Dodja
is
qui fait
that
état de la
the
nomination
appointment
d'ex-Seleka
of
à
President
des postes
Jotodia also led to the
ce qui
appointment of
renforcerait
ex-Seleka
ainsi, selon
members
l'accusation,
to
la
positions
position des anciens
of
leaders Seleka
ministers, thereby consolidating the position of the former Seleka leaders, which, according to the position, were loyal to him and obeyed his orders. And yet we have seen that not only was the government of President Jotodia a government of national union, but also the leaders of the former groups which temporarily constituted the Seleka coalition were not answerable to anyone, and more specifically made a mockery of the state structure. At no point did the prosecution demonstrate this reality. There was no prosecution of the Seleka coalition, nor was there any mention that the former coalition in any form or shape was integrated into the state structure. On the contrary, what emerges from the prosecution evidence itself is the existence of common law criminality, and the state was incapable of dealing with this situation inter alia because they did not have the necessary resources. It was within this context that the OCRB and the SEDAD, in their capacity as state structures, attempted to remain functional. We have already demonstrated that the OCRB was primarily a police station that had to intervene in a period strongly characterized by criminality. The witnesses themselves stated that the OCRB habitually dealt with common law offenses and crimes, and that the detainees were common law criminals and people masquerading as Seleka who had been arrested by the elements of the OCRB. This OCRB was therefore not a Seleka base but a state structure under the authority of the Directorate General of the Police and the Ministry of Security. They complied with the jurisdictional processes under the supervision of the public prosecutor. The prosecution interprets the existence of volunteers in the OCRB, such as Mr. Said, who collaborated with Mazenge, the director of the OCRB, as evidence that it was a Seleka basis, based. But this is not a revelation. The highest ranking officials of the state stated that there was a severe shortage of personnel and that the FACA had fled, and it was not only until the month of August that some of them returned and resumed their duties, and that even upon their return, the state structures were still facing serious shortages in personnel, and it was for that reason that they had to be realistic and accept the assistance of volunteers to attempt to contain the criminality in Bangui. The problem of the prosecution is simple. They cannot prove that the OCRB was a Seleka base where there was a hierarchical structure within which Mr. Said played a role. They cannot prove that there was an organization within OCRB, and so they circumvent the difficulty by placing emphasis on the excesses that apparently took place on the OCRB, and by presupposing the leadership role of Mr. Said, they are attempting to attribute such acts to him in the hope of covering up the evidence concerning the liability or responsibility of Mr. Said. But the demonstration of the prosecution does not resist scrutiny because it appears from its evidence that the OCRB is a dysfunctional location without a structure, and consequently it is not possible to assume that Mr. Said was responsible for everything that happened there. And particularly, we have demonstrated that several individuals there acted on an individual basis. The same reasoning applies to Sadat. I will say one word on the state policy. The prosecution does not attempt at any time to establish its existence. And yet one can only point a light on the events that occurred in the OCRB and Sadat within the framework of the judicial characterization of a crime against humanity, as from the moment when the prosecution must have established as a prerequisite a state policy, a structure within which the OCRB and Sadat operated. Did the prosecution had enough evidence to ascertain this, whether there was a state policy? Yes, obviously. As they recalled in public hearing in response to the defense, which commented on the gaps of the investigations of the prosecution, inter alia, the fact that there was a lack of certain key witnesses. The prosecutor stated, and I quote page 55, lines 22 to 25, the other witnesses referred to by the defense were also interviewed, including within the broadest context of the conflict. The prosecution also acknowledged having interviewed certain key witnesses to understand the crisis, but they did not draw the consequences therefrom. Why did they not use that information? Why did they ignore portions of the testimonies that would make it possible to make a determination on the state policy? And why set aside the pertinent and even crucial testimonies of certain witnesses interviewed, such as P1019. These witnesses are supposed to have been part of the state policy that made it possible, according to the prosecution, to establish crimes against humanity. And if that is the case, these witnesses were actors of that state policy and therefore must be prosecuted. And yet,
l'accusation maintient sa position que les témoignages
it is understood during the hearing that the prosecution stands by its position that the testimonies of the high-profile actors is not enough to support prosecutions. And insofar as the prosecution does not prosecute them because they feel that the evidence is not enough, it is tantamount to saying that they do not have enough evidence to establish this policy of the state. And therefore, the allegation of crimes against humanity and charged against Mr. Said collapses because the facts charged against him must fall within the context of the prosecution's allegations in the state policy that is supposed to have existed during the presidency of Michel Djotodia.
Le procureur les a rencontrés.
The prosecutor met with them.
Le procureur considère qu'ils n'ont
The
pas de rôle dans une
prosecutor
politique
considers that they did not have any role in the state policy because they did not use their testimony. So Mr. Said
alors, Monsieur Said
cannot
devrait l'être
be
encore moins.
prosecuted. And if these
L'accusation
witnesses
doit
are
être
not
cohérente.
bothered, there is even less justification for Mr. Said
Elle ne doit
to
pas
be charged.
plaider une chose
The
l'existence
prosecution
d'un crime
must
contre
be
l'humanité,
coherent. They cannot plead one thing, that there was the
suppose
existence of a
l'existence de la
crime
politique d'un
against humanity, which presupposes the existence of a state policy.
et le contraire,
And
qu'il
then
n'est
it's
pas nécessaire de prendre en compte
contrary,
les témoignages
that
de
it is
plusieurs
not necessary
responsables
to take
politiques
into account
pour
the
tenter
testimony
d'établir la politique
of
de l'État.
several political leaders to try to establish the state policy.
Surtout
Specifically,
que contrairement
and
à ce qu'à la
contrary
législation,
to the
la procureure
prosecution
était clairement en contact avec
allegations,
ces témoins
the prosecutor was
2013.
clearly in contact with these
Pendant les événements.
witnesses as early as 2013 during the events.
puisque P10
Because P1019, which the accusation, or rather which the prosecution decided to discard, stated clearly, unequivocally concerning his relationship with the prosecutor, the former prosecutor, and I quote, "She gave me advice, we have to avoid violence and restore peace." P document 323 1172 lines 1009 to 1010. So it was necessary to describe the crisis with this witness. The defense took act of these elements, developing all these arguments on the basis of the testimonies of knowledgeable people, because the accusations against Mr. Said calls into question the government of Mr. Jotodia. Consequently, in the absence of the Seleka structure and the state policy, the crimes against humanity also collapse and the charges must be dismissed. So what remains of the case file presented to you by the prosecutor? Nothing.
Monsieur le Président,
Mr. President,
Madame, Monsieur les juges,
Your Honors,
nous sommes rapprochés de la vérité en écoutant l'accusation.
we
À
came
l'évidence,
close
non.
to did we come close to the truth while listening to
nous
the
en sommes
prosecution?
éloignés,
Obviously, no.
car la réalité
We
qu'elle nous a
went
dépeinte,
further
c'est une
away
réalité
from it
fantasmée.
because the reality that they told us about
Le récit
is
proposé par l'accusation
imaginary.
occulte la
The
complexité de la
prosecution
société
account
centrafricaine. Et ce qui prouve la complexité des
overlooks
événements
the
récents
complexity
s'étant
of the
déroulés
car situation,
dernières
and
années en
this
Haïti.
complicates the events
Ce sont les
that
nombreuses procédures judiciaires
happened
existantes
during
concernant les
the
faits qui s'y
years,
seraient déroulés,
the last 20 years,
notamment la création d'une
and
cour pénale
there were
spéciale
normal
et le nombre
certain
important d'affaires
judicial
devant la
procedures
CPI
that
qui
existed,
concernent ces
particularly the creation of a special court
Il nous
and the
appartiendra,
important number of cases before
dans
the
une
ICC.
situation
It is therefore
et un contexte
incumbent
contentieux
upon
complexe
us in a complex
de bien distinguer
situation
entre les faits
to make a clear
qui relèvent des
distinction
juridictions pénales
between
internationales de
facts
ceux qui relèvent du droit
under
commun.
international criminal law and those under
Il
common
nous appartient de
law.
donner
It
l'opportunité
is
aux
incumbent
Centrafricains
on us
de
to give
pouvoir
the
se saisir de
possibility
leur destin.
to Central
Et c'est là où
Africans
cette
to
audience
take
prend tout
charge
son poids.
of their destiny, and that is where this
Une
hearing
audience
takes up all
qui,
its
comme le
importance.
rappelle la jurisprudence,
A hearing which,
un mécanisme
as
tendant à protéger
recalled
les droits
by
de la
case
défense
law, is a
contre des accusations
mechanism
abusives
intended
entièrement
to protect
C'est l'occasion
the
parfaite
rights of
pour refuser de suivre l'accusation
the defense
tente de
against
poursuivre des
any
faits qui ne relèvent pas
violations
de
and
juridictions
abusive
pénales internationales.
accusations and which are unfounded. It is the perfect opportunity
Il
to
appartient
refuse
de
to
donner
follow
aux
the
acteurs
prosecution.
judiciaires locaux le
It is
pouvoir de décider de
incumbent on
l'opportunité des
us to
poursuites
give
et
the
d'établir
local
les
jurisdictions the possibility to initiate prosecutions and to ascertain
Madame,
the truth.
Monsieur les
It is
juges,
up to you, Mr. President,
appartiendra
your
de rappeler
honors,
à tous
to
ceux qu'il ne
remind
peut y avoir de
all
justice sans vérité.
those who are listening that there
C'est sur les
cannot be
épaules de
justice
l'accusation que repose la
without
charge de la
truth.
preuve.
It is the
Pas sur celle de la
pillars
défense.
that it
La
is
défense
the onus of the prosecutor
tenue
to
ici
provide
d'apporter
the
les
evidence,
éléments de preuve
not
contraires,
the defense.
mais
The
simplement
defense
de
is
montrer
not compelled
les
to
éléments
provide
présentés par
contrary
l'accusation
evidence, but simply to
soutien de son
show
argumentation
that the evidence
pas
provided
suffisants
by
pour
the
justifier
prosecutor to
confirmation des
support
charges.
its charges are not sufficient
L'accusation
to
se paie de mots.
justify those charges.
Nous avons à nous intéresser aux faits.
The
Les
prosecutor
faits découlent de la réalité
has
et la réalité.
to
est
say
là,
their words,
sous vos
but we have the
Prenez-en
obligation to look at the
Tirez-en
facts,
toutes les
and the
conséquences.
facts are there before
confirmez pas les
you.
charges contre
You
M.
have to
Saïd.
analyze them, and
Et ce
then
sera
you have to
justice.
draw all the
remercie.
consequences. You should not take into consideration the charges against Mr. Said, and then justice would have been done. Thank you.
Thank you very much, Madam Counsel. Now, with the final statements of the defense, we come to the end of the confirmation of charges hearings. As parties and participants know, the decision on the confirmation of charges has to be delivered within 60 days from today. Mr. Said, you should understand then that in 60 days, the Chamber will deliver its decision on whether the charges brought by the prosecutor should be confirmed or not. And this is done in accordance with Regulation 53 of the regulations of the court. I would like to thank all the lawyers of the prosecutor, of the defense, of the PCV, the interpreters for their professional work. We appreciate very much. Court reporters, technicians, security officers, and all staff and representatives of the registry for their cooperation. So the hearing is adjourned, and we wish everyone a pleasant day. Thank you.
All rise, veuillez vous lever.